During probate court, some of the common disputes that we see relate to, is a will actually valid? And this is where we see potentially someone that maybe didn't have capacity, right? They didn't have the mental ability to understand the document that they were signing. If they were giving away all of their estate to one of their children because they were under duress and they didn't necessarily know what they were doing when they signed that document. So, this is one of the biggest issues that we see when it comes to people contesting things in probate court. If somebody feels like a will may not be valid, there may be reason to contest it. Now, when we look at contesting a will, it's important to look at all of the facts that are involved leading up to signing of that will. What influence did the people have over the person who signed the will? Were they in their right mind and capacity to do it? Because if there is a will, there's likely some language that would say something to the extent of a no contest clause. A no contest clause means that if somebody were to contest the terms of the will, then and they were unsuccessful in their contest, then they would receive nothing under the terms of the will. This can sometimes be a reason where people would not want to contest because they're afraid that they wouldn't receive as a result of being unsuccessful in their contest. One of the things that we generally will do when we first um, speak with a client that is looking to contest something is really understanding the facts. And if there is legal counsel on the other side, we will then have a conversation with the opposing counsel to understand and voice our concern, then generally follow up with some type of letter with our intention to contest. This will then give them the opportunity to respond back with the evidence that we would need to make that decision on whether we wanted to contest the will or not. If you are looking at contesting a will, you will need to file a petition with the court to contest that specific will. In that petition, you will identify the reason that you are contesting the will and make sure that when you file it, you need to give notice to everybody that is receiving notice through the petition. A few things that can help to reduce family disputes in a probate proceeding are to have open communication amongst all of the family members, whether it's the person who created the will and is signing it, being open with what their distribution looks like, who they've identified as the personal representative, because it's when people don't know and they're caught off guard that oftentimes it leads to a lot of frustration and a lot of anger. And that builds up into people making bad decisions in things that they do and next steps that they take that are probably going to end up costing the estate a lot of money. Oftentimes, we see this where you have multiple beneficiaries that have now hired legal counsel. You have the estate that is now also paying additional fees. And so, really, it's then having to just pay most of the money to attorney's fees and costs associated with fighting some type of will contest. So, if you can plan ahead and know that there may be some issues that you need to care for ahead of time and make sure that that communication is open, it's definitely going to allow you to be able to make sure that people are going to understand and get along better when this happens. So, a legal option to resolve a conflict in probate court is mediation. This is where generally the parties come together and decide on a mediator. It's usually paid for out of the estate. And at that point, the both sides or whatever parties are involved would file a mediation brief with their side of the story. And then they would work with the mediator. The mediator generally is going to take place if it was like in a room or in a Zoom meeting where the mediator would work with each party individually and kind of go back and forth to ask questions and understand what's going on and help them to try and come up with some resolution that all parties are okay with and that they can then take back to the court. I had a case It was a probate proceeding that was going forward. My client was the son, and he wanted to contest the will. The will that was filed, that was being brought forth in front of the probate court, um, didn't even identify him as a son in the petition. The will didn't mention him as a son. And so he came to us because he didn't agree with this will. He was very close to his father. And as we started to kind of peel back the onion and uncover the facts of the case, what we identified is that there was a nephew that had gotten involved and had started visiting the father that had dementia and forced him to sign a will that he did not understand, or that we believe he didn't understand because of his dementia. And in the will, he did not identify that he even had this son. And that's really what brought these facts to our attention, that there was some type of wrongdoing. Um, we believe that the nephew was just out for the money, and that he essentially was brainwashing the father to believe that this son didn't exist, or that he wasn't his own blood, that he was through a an affair that the mother had had. And it's so sad in these situations, because this was our client's dad that put this in writing, and had it signed by a notary and a witness. But we were able to discuss these facts with opposing counsel, give them our point of view and the reasons that we did not believe it to be valid, and some issues with how we think things were executed. And they actually did withdraw the will and the petition. And our client was able to then be nominated as the personal representative of the estate, because he was the only living child at that time. If you need assistance through a probate proceeding, if somebody has passed away, or you're looking at avoiding probate court, please consider calling us here at Hermance Law to assist you.